live outside federal court.
Yeah, that's right, Meg. We're with former Assistant U.S. Attorney Matt Coleman. And Matt, we're talking to Stephen Stock, our investigative reporter. He talked to Jordan Ginsburg shortly after the indictments were handed up and was told that it was multiple counts. We're still waiting to get the indictments in our hand, but is there any surprise there? What can we read into that little bit of information?
No surprise there. I mean, you're rarely going to have an actual indictment where it's going to be, confined to just one particular count. You'd see that in maybe a guilty plea, where, there's some agreement beforehand where there's a factual basis, a plea agreement, and a bill of information. But in an indictment that's going to be contested, you would expect to see multiple counts.
Have there been any discussions, do you think, between the assistant U.S. attorneys involved in this case and Cantrell's attorneys? Would any negotiations have begun, or is there any kind of interaction up to this point?
That's always possible, and of course you never know. Only those particular parties know. You would typically have at least the issuance of a target letter, where obviously if you have a putative defendant, the Department of Justice manual dictates and mandates that you go ahead and issue a target letter and invite that particular putative defendant to the grand jury if they would wish to attend. That would probably have happened here, and likely Ms. Cantrell would have declined that particular offer. There potentially could have been some settlement negotiations, plea negotiations, but you really don't know at this point.
Once that letter is issued, would that make a would-be defendant sort of reticent to give any comments whatsoever about anything having to do with the legal ramifications of what she might say? And could that be a reason why we've seen so few news conferences from her in recent months?
Yes, 100%. I mean, that's going to be super rare, not unheard of, but super rare for a particular putative defendant to go ahead and take that invitation and to actually present testimony to the grand jury. One, at that point, the indictment, is probably in the works anyway, and you're only going to do yourself damage by presenting some testimony that you're really not exactly sure of the context of how it's going to be. You can't control it. Your lawyer's not in there with you in the grand jury room, so it's very unlikely that that particular episode occurred.
Is a case like this being handled strictly out of this U.S. Attorney's Office, or is there a public corruption unit out of Washington, D.C. that could be involved in this prosecution?
There is a public corruption unit. It's called PIN, Public Integrity, but as of yet, you haven't seen any of those individuals sign any prior indictments of Mr. Vappy or Mr. Farrell. So I believe, at least at this point, it's going to be just on the U.S. Attorney's Office here in the Eastern District.
I know they were active in years past, been very active in Louisiana in years past. It doesn't seem like we see as much out of them as we used to. At what level, when do they decide to get involved?
They'll typically be involved when the local U.S. Attorney's Office may recuse itself for having some conflict of interest. Public integrity will usually step in at that point. Or sometimes they can also have their own investigation in cases that they prosecute out of Washington, D.C. But if a local U.S. Attorney's Office takes that case, there's no particular reason for public integrity to be involved.
Matt, what is it like to prosecute a popular figure like a mayor, someone who's been elected twice by a majority of voters in a parish? How do you wipe that out of your mind to go about, as a prosecutor, to go about the business that you must tend to?
You certainly have to follow the normal, traditional, standard approach to any type of investigation prosecution. To uncover probable cause and sufficient evidence to prove beyond a reasonable doubt that a particular individual committed a particular specific violation of a federal criminal statute. You can't start chasing headlines. You can't chase a particular individual, nor shy away from doing that just because they're an elected official.
Any way of quantifying the amount of man hours that go into a case like this by the attorneys involved and by federal investigators? Countless at that point. They're probably, it's not the only case they're actively pursuing, but it's going to be one of the few, given the ramifications, given the scope, and given what's at stake. Could you share with us what goes into the actual charges that will be brought by a grand jury? What is it's not the same burden of proof as a criminal trial, but there has to be a pretty high standard to include certain charges in an indictment. Can you walk us through how that process works a little bit?
Sure. The grand jury finds probable cause. and that's it. That's their standard. That's the level of proof that's required to be presented to them, and that's what they'll return, and that's what apparently happened this morning, this afternoon, I should say. And then obviously at the trial level, it's going to be up to a jury. All 12 must decide on a legal verdict, and that's going to have to be guilty or not guilty, and that's got to be beyond a reasonable doubt. So two different standards at play.
Did you handle the naked grand jury?
No comment.
Can you say whether you've handled grand juries before?
100%. Every assistant U.S. attorney handles all grand jury matters. It's a vertical prosecution where the cases are taken from the investigation stage all the way through trial and then appeal.
So a grand jury that's been meeting as long as this one has, we believe over a year, do they get invested? I know you don't want anybody's personal grievances to get involved in this, and they're all vetted to make sure that they could act objectively correct. But in terms of just doing the job, is there kind of a will to want to see it through to some conclusion, or does it just depend?
It just depends. The grand jurors that are impaneled have traditionally have had no issues with recusals or conflicts. If there's an issue where a particular grand jury would happen to know a witness, they can raise that to the assistant U.S. attorney and or the district judge. That person can then remove themselves, and the other grand jurors can take the case itself. As you said before, the grand jury is a body of at least 16 voting, or at least voting, and then 12 to actually pass an indictment, but you can have as many as 23. So that flexibility in those numbers allows for people to recuse themselves, step out the room, and the other grand jurors can take the case from there.
You've handled both kinds of juries. Do nerves get as frayed as they would in a normal criminal trial, or is it more relaxed than that?
Criminal trials are a beast of themselves, and especially when there's media attention, and given the stakes, that's going to be different. The grand jury is a formal, recognized process, but the outcome is not as much in play as it would be in a jury trial because of the standard is so different.
Are there different standards involved in deciding whether to bring a bill of information against a defendant or to try and get an indictment?
Correct. A putative defendant has to agree to a bill of information for a felony. So that has to be by agreement to proceed in that fashion. And that's 95% of the time standard when someone is pleading guilty and there's been some pre-charging agreement between the defendant and the government. But if there's been no agreement, that's going to proceed by indictment, not by bill of information.
Would that happen with somebody who's been given a target letter, or would that normally happen with somebody who may be cooperating with the prosecution?
Bill of information is going to be someone who's cooperating with the prosecution, 100%. And that person may or may not have received a target letter themselves, typically not. Typically the target letter is for that putative defendant that has already expressed almost no interest in pleading guilty prior to some indictment. So you typically see two paths. You're going to see a bill of information without a target letter. You're going to see an indictment with a target letter that the public doesn't know about, but the defendant receives, and then the indictment, and then eventually a trial or a guilty plea, because those are the only two options.
Most of the people we've seen involved in this case were, prior to today, it is assumed that she was mentioned as public official A, have been indicted. I don't know if we've seen too many bills of information in this case. Correct me if I'm wrong.
That's correct.
Can we read anything into that?
No, because some may be sealed. So you never know what goes on behind closed doors as far as that's concerned, or some that may be filed between now and some trial date. So you just never know exactly what the timing would be. There was something that you could read into from last year's indictments, obviously, that she was identified and referenced as public official A, which would typically mean that she's going to be indicted. It's taken some time, but it's led to this date nonetheless. But as far as others, you just have to wait to see.
Would you be surprised to see some bills of information unsealed in this case?
Not necessarily.
How important, there's been a number of phone calls that were brought in the DAPI investigation. What do we know about the surveillance that was used so far in some of these previous indictments, and what sort of evidence do you think, can we speculate as to what sort of evidence might be presented when this case is brought to trial? Is there a standard of evidence that must be met, and is electronic surveillance techniques part of that standard these days?
It's typically part of that standard or what you see out there, but in historical public corruption cases, it's less prevalent. If you're talking about a narcotics investigation, you're going to see consensual recordings, wiretaps. In the Edward Edwards case, for instance, there was long-running wiretaps on multiple phones, multiple targets themselves. But in a historical public corruption case, you typically won't see that. You're going to see a lot of paper, you see a lot of cooperating witnesses, you're going to see some financial transactions, and then all those laid out in kind of a chronological or sequencing order so that the jury can understand the full picture of what occurred.
Mayor Nagin and LaToya Cantrell were elected twice by the people of this parish. Of course, the Eastern District of Louisiana comprises multiple parishes around the area. Is it still difficult to get jurors in a case like this who don't have any sort of preconceived thoughts about the sitting mayor?
Not as difficult as you think. In the Ray Nagin case, obviously, as you pointed out, he was elected twice. Obviously, it's only how many times you can be elected under the city charter. And that was brought up during voir dire, during jury selection. People's voting patterns, those were handled on the side with Judge Berrigan. But we were able to seat, Judge Berrigan was able to seat a jury within one day, and we were doing opening statements soon thereafter.
Wow, that's incredible. Is it any more difficult to get an impartial juror or jury when you're dealing with an elected official?
It is, just because that particular individual is going to have, is going to be known by more people. People will have voted for them. As you pointed out, the Eastern District's multiple parishes. It's 13 parishes altogether. Most of those individuals will know of LaToya Cantrell, and potentially many of them will have a preconceived position or thought about her. But that's not the standard. The standard is, even knowing that, can they put that aside and render a verdict based on the evidence and the witnesses that are presented? And once an individual honestly says, yes, I can do that, that's all that needs to be met. So it's not just knowing of that particular individual.
Now, what kind of time is going to be required of these prosecutors to conduct this trial? I mean, you're in private practice now, correct?
Correct.
Are you spending more time at home these days? I mean, these guys are going to have a lot of long days coming up, correct?
They are. It just depends on when the trial is set. There's going to be, an initial stage of discovery that's going to be produced, maybe some pretrial litigation regarding the discovery, potentially before the magistrate and or the district judge. From there, there'll be somewhat of a lull where the defense attorneys are reviewing that discovery. There'll be some pretrial cutoffs for motion practice. Once those motions are filed, then it will start to ramp up. And then as you get closer to trial, 90 days beforehand, 120 days, witnesses will be subpoenaed for trial, hotel, travel, lodging, everything from there. So it'll be somewhat of a lull in the middle and then ramp up towards the end.
What's your take on what's been going on with the U.S. Justice Department and some of the changes? Should we be confident these same two assistant U.S. attorneys will be prosecuting this case, or is the Justice Department such that we may see some shakeups?
I would expect that the team that you just saw walk out will be the team that goes to trial with that. You may have addition or deletion of one or two, which is, common. But for the most part in the field, most U.S. attorneys' offices remained intact. There's always going to be turnover from administration to administration. But as far as these types of cases, those people that indicted it, you would expect them to be the ones that tried as well.
Can you shed any light for us as to how that team will work? How many lawyers will be involved in this case? What are some of the tasks that they'll be faced with as the trial unfolds?
Typically have 3 to 4 assistant U.S. attorneys on a case of this magnitude, so to speak. Sometimes it could be a little as 2, as many as 4. You'll typically have a breakdown of tasks as far as discovery and pretrial litigation, as well as in a trial there's going to be a breakdown, because you have to have a breakdown where one individual assistant U.S. attorney, probably one defense lawyer per defendant, will conduct voir dire in conjunction with the court, and then from there there'll be opening statements. Only one person can do that. Closing statements is divided into 2, because there's a first close and a second close by the government, because the government carries the burden. Defendants only have one opportunity for a close. So you'll typically see that divided up amongst those people on the team.